Welcome to this fourth event in our series on power and accountability in tech, brought to you by the UCLA Institute for Technology, Law and Policy, a new interdisciplinary research center whose mission is to foster research and analysis to ensure that new technologies are developed, implemented, and regulated in ways that are socially beneficial, equitable, and accountable. My name is Michael Karen-Nicholas, and I am the Executive Director of the Institute for Technology, Law and Policy. I'll start by acknowledging UCLA's presence on the traditional, ancestral, and unceded territory of the Gabrielino Tongva peoples. Our event today is meant to present the practical and structural challenges that regulators face in establishing meaningful accountability for global tech giants that have expanded so rapidly into virtually every aspect of our day-to-day lives. What does public accountability mean in this regulatory context? What responsibilities attach to these transnational companies across the jurisdictions where they operate? And what should an effective regulatory posture look like? We unfortunately, I should tell you at the outset, received word back from one of our panelists, Eduardo Bertoni, that his flight yesterday was canceled and rebooked today, so he will not be joining us. Flight delays for a panelist. It's almost like we're back to the real world again. But yeah, we still have an outstanding panel who I'll introduce now. Dr. Anne Cavoukian is the Executive Director of Ryerson University's Privacy and Big Data Institute. Prior to that, she served 3 terms as the Information and Privacy Commissioner of Ontario, in which capacity she created the Privacy by Design framework, which has since been translated into 38 languages. There's much more to her bio than that, but I want to leave some time for discussion, so I'll move on. Alex Albin is a lecturer here at UCLA Law who teaches several classes on privacy and internet law. He formerly served as Washington State's first Chief Privacy Officer until 2019. And he has also had a distinguished career in the private sector, working for several pioneering internet companies and as a representative of the tech industry before the US House, Senate, and Copyright Office. He is the author of Analog Days, How Technology Rewrote Our Future, as well as a number of other academic and mainstream articles. And our moderator today is Andrew Selbst, an assistant professor at UCLA School of Law, whose research focuses on how the creation, use, and proliferation of different technologies can interfere with existing legal regimes, and how legal actors can most usefully anticipate or respond to the social effects of new technology. Before UCLA, he was a postdoctoral scholar at the Data and Society Research Institute, and he has held visiting and adjunct positions at Fordham University School of Law, the Yale Information Society Project, Georgetown University Law Center, and the Electronic Privacy Information Center. We are hoping to get some time for Q&A towards the end. So I would invite all participants, and anytime you have any questions or want anything to ask, to throw it in the chat, and I'm sure the panelists will get to that. And I'm excited for this conversation. Over to you, Andrew.
All right, thank you so much, Michael. Just to set the stage for what we're gonna, how this is gonna look today, we're going to start off with a couple of questions that our panelists have been made aware of ahead of time, so they can give a little bit of longer form thoughts on, and then we'll move to more shorter questions where hopefully we can generate a conversation and then get in anything from the Q&A in the chat to get going. So the first question I want to ask you both, and I guess I'll start with you, Anne. What does meaningful accountability or responsibility for tech companies look like to you, and what do you see as the biggest challenges in achieving it?
Tech companies have to understand that the information they collect from their customers, from individuals, this is their personal information. It's often personally identifiable, and it relates directly to individuals. In terms of the protection of that data, that is what is essential. And that's what tech companies have to understand. They can't just collect this data, use it in ways that, that they want to use it to, make it available to third parties. None of that should be taking place without the consent, notice and consent of the data subjects, the customers. So what I always like to remind tech companies is, you may have personal information relating to your customers, but if you want to use it in the context of some kind of data format, excuse me, it's got something in my throat. If you want to use it, there's 2 things you can do. You can obtain the positive consent of the customers, the individuals involved, to use their personally identifiable data. Most tech companies won't be doing that. Or you can de-identify the data, meaning you can apply very strong personal information removal in terms of removing personal information, personally identifiable data associated with the information. And that way, you can still have data that you can utilize, but you won't have the privacy risk associated with it because the personal identifiers will have been severed. And you have to do this carefully. When you're removing the personal identifiers, it has to be done in a very thorough manner, combined with the risk of re-identification framework. So there are de-identification protocols you can use that are very strong. That way, it frees the data, if you will, to be used by the tech companies in whatever way they want, so they preserve data utility, but they don't risk the privacy of their customers, of their data subjects. And that's critical. This is what I like to remind tech companies again and again. And the best way to do this is implement privacy by design, which is all about being proactive. It's proactively embedding the much needed privacy protective measures directly into what you're doing, into your business operations at the tech company, whatever. So that way, it's not an afterthought, it's a model of prevention. You embed the much needed privacy protective measures into your operations, you strongly de-identify the data, and then you're golden. You can make whatever use of the data you want in a de-identified manner. But that's critical. If you don't do that, you're going to risk not only your customer's privacy, but they take it to court these days. I mean, they will come after you, and they're not just lawsuits, they're often class action lawsuits. This is very serious. People care more about privacy today than they ever have. In the last 2 years, all of the public opinion polls, Pew Internet Research, et cetera, have come in at the 90 percentile. 90% very concerned about their privacy, 92% concerned about loss of control over their personal information. And privacy is all about control. Personal control over the use and disclosure of your personally identifiable data. So if tech companies are smart, they'll strip the personal identifiers, they'll de-identify the data, and then they're golden.
Okay, thank you. Same question to you, Alex.
Thanks, and just thank you and the ITPL for inviting us to be here today. I agree with what Anne has been saying about the measures that would be taken in I guess an ideal world, but as you know, we don't live in an ideal world, especially in the United States, as compared to some other jurisdictions. It's interesting to observe that basically in the US and actually in most of the world, privacy law is still in the notice phase. If you give notice of a practice, usually through a privacy policy, but maybe not, then a company is absolved of most responsibility. And that's why we have, 30 and 40-page privacy policies that nobody reads. So I think the story of privacy over the next 5 to 10 years is going to be a shift from a notice-based regime to a consent-based regime. And that raises the question, well, what do we mean by consent? A lot of people ask me about devices that they've purchased, and they say, well, I never consented to giving that device my personal information. And you can take an example like the Amazon, we call it the Alexa, right? That device, the Echo. When is consent actually given for Amazon to collect information? Because when you purchase the product, you plug it in and it activates. You're not asked at that point to give consent about where your information is going or who may be in the room or how it is used, right? And I think that for most people, they say, well, I bought the device, I guess I consented to it. But of course, they didn't consent to the myriad ways that their information is going to be recorded, kept, sold to third parties, packaged down the road, profiled, given to data brokers. So there's an entire long tail economy. And for me, the really important question that everybody, I guess, in this forum needs to be thinking about and working on is, how do we express consent? I'm very unhappy with proposals that say, well, just click when you start using the product. I really don't think that that's a meaningful type of consent. And I don't think consumers understand what is going to happen to the data. So we need to have a more active consent regime where a new use of data occurs. The company should have to actually go back to the consumer and say, you know, you consented for use of your data to use our product. That's great. Now we are intending to give it to a partner so that they can market to you this other amazing product that you're going to love. That's a point where a company should say, oh, we need to get your consent again. We need a meaningful consent to this new type of use. I think that that regime is possible. It's certainly technically possible, but we don't have it. And as you know, basically, we have very few privacy laws in the United States. We are under the California Consumer Privacy Act in the state of California, and yet that is not an opt-in law, it's an opt-out law. So there are many barriers, and we can talk about this, you know, later, Andrew, to consumers actually expressing what they want to happen to their data, because there are many issues with the opt-out regime. But basically, I think we need to make this transition to consent, and it's going to take a lot of creativity and a lot of different stakeholders to make it happen.
All right, thanks. I've got the second sort of bigger form question prepared, but I really want to follow up on this idea of notice and consent. I think a lot of the trouble people find with these tech giants, and you know, I'm someone that focuses less directly on information privacy and more the later stage uses with algorithms. And so maybe this is just coming from my perspective, but some of the concern I think a lot of people have with data is that, you know, if I consent to something, it will affect someone else's life chances, right? If companies have a certain amount of use of data, there's an implication not just of the individual, but on other people in general. And so I wonder if there are inherent limitations to notice and consent that we should be thinking about.
Andrew, if I may, I'm going to suggest to you that the exact opposite could be happening if you don't engage in notice and consent. I just want to pick up on one thing Alex had mentioned. He talked about Alexa. I'll never forget reading about this case where this woman, you know, she had an Alexa in her home, and she got a call from a friend of hers, and the friend said to her the next day, oh, I didn't know you were having problems in your marriage. What's going on? I wasn't aware of that at all. And the woman says, what are you talking about? How did you know about that? We haven't told that to anybody. We just talked about it last night. And she said, oh, well, I heard it via Alexa. Alexa told me. Basically, the unbelievable connections that were never consented to or thought through. These are the kind of things that can take place if you don't have strong notice and consent. What consent does, I mean, I always like to frame privacy as control, personal control over the use and disclosure of your personal information, which requires a consensual kind of model so that the individual, and I always tell people, look, you want to give away your information, be my guest, as long as you make the decision to do so. And so consent doesn't necessarily mean restricting, but it's knowledgeably addressing the issue of who will be using my information, to whom will it be disclosed, and the data subject, the individual, has to make those decisions. It's critical, and this is doable. As Alex said, there's been, you know, many privacy laws all around the world, very strong ones. Privacy by design is taking place. It's now translated into 40 languages. There's a lot of concern associated with people's personal information. And the consensual model in terms of positive consent addresses that very clearly.
So, Andrew, I'm not sure I completely understood your question. Were you saying that when one person's data is used, it affects other people without their knowledge? What's an example of that?
I guess I fully support the need for more consent, but I wonder the degree to which privacy should be solely framed as an individual right as opposed to a societal issue, right? That where one person's privacy affects other people's.
Well, it's interesting. The California privacy law has a definition of household And that's an interesting concept too, because we bring something into our house, particularly in the context of the IoT, and many people are going to use it, including children in the household, right? Parents in the household, friends who are coming by. And there's very little control over the rights of those individuals. They're sort of just walking into a surveillance zone, whether they know it or not. In terms of Anne's example, I mean, if that conversation of this person was recorded and used without their knowledge, I mean, that's a violation of Amazon's privacy policy, right? I mean, that they should be or could be sued because that is not the way they say the product works. And I have had extensive conversations with Amazon's privacy team, and they swear up and down that this product is not ambiently recording conversations, right? So tech companies need to be held to what they're saying their products do, for a starter.
I totally agree.
Yeah.
I mean, I'm sure that was not an intentional disclosure
Yeah.
of that person's intimate personal conversation with their husband, but it's not the only time it's happened. Unfortunately, these things do occur. And so the kind of protections I'm talking about, they need to be instantiated and put into place. And Andrew, you're talking about privacy at a societal level, but with due respect, privacy relates to an individual's personal information. And it has to be that individual who retains control over the use and disclosure of that information. It doesn't mean that it shouldn't be shared at a societal level as long as they're willing to do so. But you can't say, well, the group decides, should this information get out there? You have no way of making those decisions. It has to relate to the individual and their decisions. You see, I always say one of the reasons the Germans have a wonderful term for this called informational self-determination, that it should be the individual who determines the fate of his or her personal information. And the reason I love that is because only the individual knows the context associated with their data. Is it sensitive? Is it not? They could care less if everybody has access to it, or they want no one to have access to it. No one knows the context and the sensitivity or lack thereof other than the individual, the data subject, relating to his or her personal information. That's why the German term informational self-determination is just resonates, that it should be the individual who determines the fate of his or her personal information, since they are aware of the context associated with it.
Great, thank you. All right, so this is all about the sort of challenges of regulation, right? So I really want to tap into both of your experience as regulators. So the first thing I want to ask is, one of the biggest practical challenges to modern day regulation is just the fact that individual companies have global reach. And as regulators, you're sort of jurisdictionally situated, right? So Alex, you were a regulator in Washington State, and you were in Ontario. A lot of the tech companies are in California or in the US in California. How does this affect how you think about your role as a regulator, the ability to control those tech companies? What are the cross-border issues here?
Well, I mean, the first thing that we look at when we draft a privacy law is, jurisdiction, right? Who do we have jurisdiction over, and what would be a meaningful presence type of test for a company in our jurisdiction? A lot of the privacy laws are framed as saying if a company has 50,000 customers or data on 50,000 people within a jurisdiction such as a state, they should be subject to the laws of that state. There's no magic number on the threshold, but I think they certainly don't have to have a corporate headquarters in our state. They don't even have to be located in the US, right? If they are handling the data of our residents, then the state has an argument that they have to have consumer protection. I think the California law is interesting, and the draft Washington law that we tried to get passed twice, tried to do the same thing, is that it's a national law, because how many companies have a presence in California with respect to having customers here? There are tens or hundreds of thousands. So this raises, as you know, the legal question of, can a state, such as Washington or California, pass a law that in effect has national reach? Because a company that's located in New Jersey is going to have to, obey the California law with respect to the privacy of the people in California. And for all practical purposes, having worked in several tech companies are not just going to say, oh, we have to just segment the California customers and have special rules for them. You can do that for a very short period of time, but it's not sustainable. So in effect, what happens is the company shifts to the standard of the state that has the restriction, sort of in the way that this happened with the CAFE standards and air quality for automobiles. Once California passed its standards for better air quality and more emissions restrictions, the rest of the country, the automobile manufacturers moved up to that standard for everybody. And it kind of works the same way for privacy. So, it's not hard to say you're subject to our law, but it's another question to say, how do we know you're complying with our law? And because we have limited resources, like any kind of regulator, we really rely on consumers to tell us, right? We rely on consumer complaints, and I'll end there for now.
Thanks.
In terms of laws, I always like to talk very broadly. And I'm going to mention the GDPR, the General Data Protection Regulation, which came into effect a few years ago in Europe, in the EU. And it is huge. The impact that the GDPR has had globally is so significant because, you see, everyone wants to engage in trade and do business with the EU without fear of repercussion or anything. And having essential equivalence with the GDPR makes such a difference in terms of your ability to engage in that kind of business and trade, et cetera. So in Canada, we used to have essential equivalence with the EU until the GDPR came into effect, and we no longer have sufficient coverage. So our federal privacy commissioner is now trying to get our law upgraded so that we can once again have essential equivalence with the GDPR. Countries all around the world are trying to upgrade their laws so that they can again have essential equivalence with this new law in the EU. Yeah. And the GDPR increases control dramatically in terms of individuals having personal control over their personal data, and it really strengthens privacy, literally globally. Another reason I was very excited that the GDPR came into effect because they included my privacy by design in the GDPR, and privacy as the default setting, which is the second of 7 foundational principles of privacy by design. And the reason I want to mention this now is, laws are very important and they, have a strong presence. But the problem with laws is privacy laws or whatever, they kick in after the fact, after the data breach has taken place or privacy infraction. You invoke the law and you execute something that resolves the situation. Privacy by design is all about being proactive. It's all about trying to prevent the privacy harms from arising proactively, so that it's a model of prevention, much like a medical model of prevention. So that if you have privacy laws in place and the privacy as the default setting, which they've also included in the GDPR, what that means is, what you say to your customers is, you don't have to ask for privacy. We give it to you automatically. It's embedded in our operations. It's the default setting. We can only use your information for the primary purpose of the data collection that you have consented to. Beyond that, we can't use it for secondary uses unless we come back to you and seek additional consent. This is so powerful. It resonates with people. They love it. And at a time where there's such a trust deficit right now globally, this builds trust like no other. So companies that have gotten certified for privacy by design have come back to me and told me they love it because it has built trust like no other. It has restored trusted business relationships where they were dwindling in the past. So it's a real positive, and it's not something you can forget because it's embedded into your systems. You bake it into the code. It always has a presence. So while I agree that privacy laws are very important to complement that, the privacy by design approach adopted in the GDPR and elsewhere is all about trying to almost prevent the need for it because you're proactively building it into your operations.
All right, thanks. Yeah. So I guess to follow on that, like how do you enforce something like privacy by design, right? I know it's written into the GDPR as a requirement, but if like what's the standard by which you have succeeded at privacy by design, other than are there privacy problems down the line that you then litigate?
Very quickly, I don't want to take up Alex's
ahead.
time, but one of the things we do is we have what's called privacy by design certification, which certifies that companies, so a company would come to me for privacy by design certification, and with their consent, I work with KPMG, I send KPMG into them to examine their operations and in fact confirm that they're following privacy by design. And then they report that to me and I certify them. And what this does is it provides such assurance to the public that they're actually doing this and that they're doing it right. And they're extending the kind of privacy protections that they claim to be.
And one way to enforce it is to actually have a risk assessment that's done by the company whenever they're collecting sensitive data, not all data, but you would define certain kinds of PII that require risk assessment. And the company does an internal exercise about what's the risk of data breach, what's the risk of using this data in a way that we didn't intend or that spills over. Some people are skeptical and say, well, then you're just trusting a company to do what it says it's going to do. But I actually think that looking at the internal ways that data are handled, as Anne has been suggesting, is really where the rubber hits the road. It's the internal practices of companies that determine what happens to data. And I am very concerned that we don't have that kind of scrutiny in the United States. There are companies such as Microsoft that have said they are going to go up to the GDPR standards with respect to their customers in the United States, which is great because that will have the effect of raising the bar in the US. But we certainly lack a comprehensive privacy protection regime. And I don't think that the current Congress is going to give us one. And so I think we need to find leadership in other places.
So yeah, I mean, so it's great that you mentioned like impact assessments and like privacy by design being included in the GDPR in Article 25, Article 35 requires data protection impact assessments for any high risk data processing. So it's in there, it's the same idea. So yeah, the GDPR made a lot of change, but I'm curious to go back to the cross-border question. Is there a problem as a lawmaker or are there problems for businesses if there are a whole lot of different competing jurisdictional ideas, or jurisdictional laws, right? It's one thing, and what you're saying is that everybody's trying to sort of raise themselves up to the GDPR, but the US very likely won't, and also will rebel against the idea that all they're doing is matching the GDPR. That's reason itself maybe not to pass it, according to at least some folks in Congress. So what do you do, right? Or on a state level, is it a problem to have a lot of different kinds of laws that companies have to deal with? What do we do about that?
Well, this is sort of, I'm sorry, Anne, go ahead.
No, you go ahead, Alex.
Well, this is what we talk about in my class, the sort of patchwork of laws problem. Anytime a state proposes to do something, or even a city like San Francisco or Seattle wants to pass an ordinance about surveillance or use of technology, they hear the patchwork of law argument. But many companies just show up and testify and say we can't possibly adhere to 1,000 different laws. Having been inside corporations for most of my career, I can say actually companies comply with different laws all the time, right? They have personnel, they have technology, and it's not an insurmountable obstacle. Furthermore, the laws tend to harmonize. So even if you look at where privacy law proposals are in the United States now, in states like Minnesota, Massachusetts, New York, Oregon, they're all about the same basic rights, right? A right to know what information is collected, a right to delete your information, a right to opt out of data sale, a right to certain kinds of consent. So they tend to gravitate towards common principles, which makes it easier for companies located in different locations to comply with the so-called patchwork. So I buy that argument less and less. And frankly, because we're in an environment in the United States where, as you observe, Andrew, we're not going to have a national law anytime soon. We're going to need to learn to live with a patchwork.
And for me, and I agree with Alex, but one of the advantages, if you will, of privacy by design is that it's not a law. There are 7 foundational principles, which are very straightforward, and you can do this anywhere globally that you want to, and it extends such. It's more the carrot than the stick. It appeals to companies, tech companies, and others, because what we're saying is if you do privacy by design and offer this to your customers, they're going to love it, and you will attract more opportunity. You will gain a competitive advantage because you're protecting their data. They want their data protected. You're embedding much needed privacy protective measures directly into your operations, and you are trying to construct a win-win. It's all about, to me, make it positive sum, not zero sum. I hate the either or win-lose model of zero sum, where you've got the stick, and if you don't do it, that's it. No, make it a win-win. Privacy and data utility. That's what I say to tech companies, to all companies that I work with, is we want to make this work for you and work for your customers. You make it a win-win, and you have this positive sum approach where, yes, you're protecting your customers' privacy, and they're very grateful to you for doing it, and you will reap the rewards of doing that. So if you construct it in that manner, it has much more appeal than the stick of a law, wherever it may be. And I just find this resonates with companies all around the world.
Great. That leads into the first question I wanted to ask from the chat. As a reminder to everyone participating, if you have questions, please drop them in the chat. I will do my best to get to them. But the first one comes from Michael, who asks what the relationship is between the enforcement powers of your office as former regulators and the tech companies. So he's kind of asking a question about kind of what you were just saying, right? The soft touch cooperative approach versus a more adversarial, like stick-based approach. And I'm curious, what your thoughts are on that. Or is it effective to have the soft power move, or when?
It is so much more effective. And I'll just say this briefly, and I'll give it to Alex. When I was a privacy commissioner, I had order making power, which meant I could order organizations to do what I wanted them to do because they were breaking the law. But I rarely used it because I wanted to work with them informally to have a resolution of the problem that didn't require the stick. The stick may be very effective in the moment, but it builds such resentment, and in future, there's no assurance that that's going to be followed. So my approach was much more one of sort of a soft sell, mediation, discussion, and getting them to buy into the reasons that they should be protecting their customers' privacy and in accordance with the law and elsewhere. Sorry, Alex, over to you.
No. Well, we in Washington State, we didn't have such a big stick, but we had the Attorney General, and so if there was a privacy violation, it was widespread, we would turn it over to the Attorney General to file a suit. And I have to say that suits are good because it's a wake-up call for everybody else in that industry. You're normally only choosing one actor to go after, and it's usually for some really obvious privacy violations and breach of consumer protection. And yet it does tend to wake up everybody else, and they pay attention. And I think hopefully, if you're doing your job right, that then lets you have the conversation that Anne wants to have, which is, okay, what are best practices that you guys need to adopt? Because we're getting, as a regulator, you're getting constant levels of complaints, and you kind of have to sort them out. Like, what's really widespread, what's very specific to one scenario. And like anything else, you have an office with limited resources and you have to prioritize, and bringing a lawsuit is expensive. And so you're constantly prioritizing what you're going to do. And, at some level, it's political.
Yeah. So,
Yeah.
The big tech companies have a lot of political power, right? They have a lot of money. They're fairly sophisticated on politics. So again, as in your experience, how do you experience that power on the
Sorry, I've got dogs.
How do you experience the power of tech companies on the ground, right? Like, how do they use it for influence? Is capture as big a problem as people imagine? I'm curious what your thoughts are on that.
Okay, my tech assistants have been barking. Sorry about that. I think that there is a lot of power and a lot of sensitivity, especially at the state level, to large corporations in your state that employ millions of people, right? And that's just the reality. A strategy is to actually enlist those companies up front when you're designing your laws. Now, some people say, "Oh, that's just giving into the corporate agenda and what they want to do." But the reality of that, and I guess I'm just talking more realpolitik than anything else right now, is I want to pass laws, right? I don't want to have the greatest privacy law ever that's never passed. Okay, I feel if I can get 80% of what we want by protecting certain consumer rights and notice and consent and remedies and fines, then we're ahead of the game. But that does require cooperation with the industry. And there are people in the industry who are very thoughtful about privacy and who care about it and view it as a positive for their company. And so you go and you find those people and you try to, influence the company internally. So it's a very engaged process.
I totally agree with you, Alex. Totally. We had strong privacy laws. I had strong order making power, but really what I wanted to do was to get through to the companies and the organizations I worked with so they understood why this is a good thing to do in terms of both their business models, their relationships with their customers, consumers, et cetera. That, I really believe in the win-win model. And so I didn't just want it to be a stick. I wanted them to understand that there are benefits to them by engaging in this, protecting their customers' privacy, having privacy protective measures that would yield benefits to the company as well as to the individuals. And that model, I find, resonates. And you get the ear of the executives. I remember a number of times I was invited by a company to speak to their board, and I would come in to the boardroom and I'd be sitting there and there'd be all these people and they were not happy to have me there. They didn't know what I was going to do and they were not happy. And I always used to say to them, give me 10 minutes. Let me tell you about privacy by design. And if after 10 minutes you don't want to hear anymore, I'll leave. I'd be happy to leave. And so I get their interest and they listen and I tell them about how there are positives to them. This is not a stick I'm bringing at all. It's quite the opposite. It's a win-win model. And that changes the discussion completely. And then I would have their attention every time and we would continue in the best way that they could frame this so that it would protect their customers' privacy very strongly and yet yield benefits to the company as well. When I talk about de-identification models, there are many ways in which you can do this. And so we would engage in an exchange about that and how to deal with the data responsibly, et cetera. But it always yielded a positive outcome when you can engage them in the discussion.
Okay, great. Let me go with another question I had missed from the chat. Given how bombarded we are with requests for information across various aspects of our lives, is it possible for individuals to make a reasonable judgment on all these choices and to know the consequences for each service which relies on the information? Or are there broader regulatory principles which could alleviate this burden on individuals?
And go for that.
Okay. You know, with due respect, individuals have to play a role in the protection of their data or lack thereof. And it doesn't have to be complicated. You know, when I always say, make sure you get consent of the data subject, I'm not saying, you know, 20 pages they have to read is not going to happen. So the way you have to construct this is in a manner that appeals to them in terms of at a very high level. What are you going to do with their information? Clear notice is essential because that will speak to the consent required or lack thereof. So you make it very clear, here's what I'm going to do with your information. And this is the only thing I'm going to do. See, if you follow privacy by design and privacy as the default setting, what that says is we're using your information for this purpose, this primary purpose of the data collection. That's what we want it for. We're going to restrict our use of that information to that purpose. And we'd like you to consent to that. That's pretty straightforward. Then if there are 50 other things they have to consent to, that's another matter. But if you can keep it as simple, as straightforward as possible, then you will engage them when there are additional uses and consents that may be required. Or they may just say, no, I don't want to have my information used for those purposes. It doesn't have to be this extremely complicated purpose.
It doesn't have to be. But I think from the perspective of the average person, it's a very complicated maze of data collection that they don't understand and shouldn't be expected to understand. And then the subsequent use of data. And it's not just corporations. It's, you know, cities and governments are collecting data all the time, right? When you, you know, purchase a home or have a deed or some sort of real estate transaction, that's collected and it's kept as a public record, and then that is scraped by a data brokerage company that has complete record of every loan you've ever had and every property you've ever owned, and then they cross that against your credit card records, and then that gets further profiled with where you live and whether you're married or not and whether you have children or not. And so I don't think people are really aware of the complexity of the profiles that are made. And I think as a regulator, it's a tough issue. You can only control your domain. You can't control everybody else's domain, and all of them now are intersecting. So the Venn diagram is a Venn diagram of a million different data collection regimes, which is very hard to unravel. I mean, I will say that maybe one area to start is to focus on the data broker industry. People don't understand how frequently their data is brokered and how many data points the average data broker has about them, or even who these data brokers are. You know, Oracle is a major data broker in the United States. I don't think they're publicly perceived that way. LexisNexis is a major data broker. I mean, these are companies that, Equifax is a major data broker. These are companies that are deriving a large portion of their revenue simply from buying and selling our personal information. You know, the first step there is just transparency. Like, who are you? What kind of data are you collecting and how are you using it? You know, and then there are subsequent steps that we can take.
Now, I agree with you, Alex. I mean, transparency and accountability go hand in hand. So starting with transparency, absolutely critical.
And right now, I mean, to the title of our talk, right, there's very little accountability. I mean, at least in the United States, because if you don't even know who's collecting your data, how can you hold someone accountable? And there's no responsibility either. There's the practices of data brokers are perfectly legal in the United States, right? They're not violating any laws by scraping data and building these profiles. It's legal.
So this, I want to key off something you were saying, Alex. There have been people that have floated the idea of regulatory models that, you know, are an overall tech regulator or sectoral based, right? In the US, our privacy law is very sectoral, at least at the federal level, right? We have health privacy, we have financial privacy, but there are these data brokers that operate in similar ways and industries that kind of go across all these different models. So you talk about Equifax, that's credit. You talk about Oracle, that's I don't know,
Data.
infrastructure. They're all in different industries, but they're all kind of dealing with similar issues. So what do you think about sort of sectoral style regulation versus a tech regulator that has, you know, experience and expertise in this area?
I mean, I think it's better to have an overall regulation that defines a data broker as a company that derives X percentage of its revenue from the purchase and sale of user data. That will cut across various industries. I mean, we really shouldn't care what sector they're in if their activity is, you know, using people's data without their knowledge and without their consent. You know, there are states, Vermont, California, have data broker registration laws, which require them basically to pay like $100 a year. You know, I'm sure there were major celebrations at all these data brokers when those laws were passed, right? Like, we have to pay $100 a year, really? And then what, you know? So we are just, you know, not even at the crawling stage of starting to regulate this big sector. And, you know, there are many law review articles and proposals that I've read that start saying, well, you need to tax the flow of data, right? Data is being used by companies. It should be accounted for in some monetary way. You know, one of the best places to start would actually be a data broker type tax on transactions involving your personal data, because we're talking about billions of dollars of transactions.
Yeah, I mean, $100, that's all they pay. It's ridiculous.
I think it's 200 in California.
Oh, gee, 200, wow. That's crazy. It's crazy. You know, for these companies to take this seriously, you have to be serious in terms of the potential penalties involved, your oversight, the kind of transparency and accountability you are seeking is critical. And you've got to build that in. You know, I agree, having one tech controller, whoever, would be far superior, who could actually put this into place.
Okay. Do you think that there's an expertise problem in government? Like, are there challenges with the relevant technical expertise and trying to, I don't know, hire people who have that kind of knowledge, or is that not necessary?
If you're talking about privacy related expertise and data protection and what they should, it's not that complicated.
Or,
I mean,
well,
yes.
Sorry, I mean, like, so these companies are like thinking about data brokers, right? Thinking about all the intricate ways in which data are being used. If we're going to have regulations that are pretty specific, that say certain practices but not others, do you require some sort of tech expertise to have this oversight, and do we have that capacity?
I personally don't think you need it. I mean, obviously some understanding of privacy, data protection, what's happening in the tech in terms of how they're using the information, in what ways. I mean, you know, you have to have an understanding of that, but this isn't that complicated. You can gain that understanding relatively quickly once you join an organization, see how it operates. And I always say you need to map the flow of data. Whenever I talk to companies, I say, do you have a data map? And they look at me like, huh? And I say, what a data map does is it literally maps the flow of data. It may enter into your company in a perfectly legitimate, consented way, but then how is that information used throughout your company for other purposes, additional unconsented usage, etc. If you have a data map, it maps the flow of the information and it makes it much easier to actually get control of what's taking place.
Andrew, I would divide your question into two domains. One is like inside state government regulators. There's a good knowledge, I think, of basic privacy practices. I think it's within the state legislatures that we have some issues where, you know, there are various levels of knowledge based on, you know, where our elected officials come from. And so there is an educational aspect to getting them up to speed about what's happening. I mean, the good news is that privacy is a pretty popular issue, and it cuts across political spectrum. Privacy on the left is very popular, right? It's civil rights. Privacy on the right is very popular too. It's freedom, right? Freedom from the government.
Yes.
The challenge actually is to bring those two together without them having to sit next to each other when they're voting on your privacy bill. And it's actually not as easy as it would seem. And, you know, unfortunately, privacy regulation sometimes gets caught up into general regulation, right? Government regulation, government interference. We have to be a lot smarter about how we pitch these laws. And I like Anne's approach because I don't think it's a threatening approach to say, if you do your business better and respect people's privacy, you're going to win consumer trust. And when you win consumer trust, you're going to make more profits because people are going to come back to you. I think there are companies that are very trusted, big companies that pay a lot of attention to this. And so we just really need to be more sophisticated about how we craft our pitch.
I couldn't agree more, Alex. You're absolutely right on.
So another question from the chat. This one moves away from privacy specifically a little bit, but our panel's about tech companies and accountability, so it's broader. So this was directed at Anne, but I think both of you probably have good thoughts on it. So if de-identification is a silver bullet, right? If we can have the idea of a lot of companies holding even de-identified data, so maybe there's no individual privacy problem, is there some sort of, is that a problem? Like, does that create some sort of obligation where a company has a mass of de-identified data such that we should be concerned about it, right? Other than in privacy, are there regulatory concerns with just the concentration of even de-identified data?
Well, with due respect, I think if you strongly de-identify the data, taking in mind a risk of re-identification protocols, things of that nature, then you have valuable data, but there is no privacy risk associated with it. So the concern cannot be a privacy related one. Now, maybe there's other business related concerns, that there may be other issues that may arise. And, you know, Alex can speak to this, but from a privacy perspective, you are golden because, and, you know, I work with people in terms of smart cities and the creation of smart cities, and there's all kinds of data that is available. But if you create a smart city of privacy where the data are de-identified at source, meaning the minute the data are collected from the sensors, et cetera, it's stripped of the identifiers, then you have a lot of valuable data that you can use in terms of the construction of the smart city and its operation, et cetera. So there's no issue there. Now, maybe in other areas, there are other laws that kick in, of course, and we have to address those. But in terms of privacy concerns, if you strongly de-identify the data, you are golden.
But I would add a wrinkle to that, in that I think it's sometimes very case specific. So take the city example. You have a lot of cameras in city parks. So you say, okay, we know that city park usage is very heavy at 9 at night, right? That tells the city how to pool resources. As long as it's not saying Andrew is in the park at 9 at night, right? We feel fine. It's privacy respectful. But I think that there are other situations where companies have troves of data that get cross-referenced. And even if they are anonymized, they still can be used for profiling, right? They still can be used to direct outcomes. And we need to be sensitive to the context, which means you just have to pay attention to what you're doing every time you're looking at a data set.
Okay.
Yeah, okay. So let's move away from data for a second, right? Back to this cross-border question from another question in the chat. Whereas in privacy, there's general consensus on the goals around the world. We need to protect personal data. The concerns roughly align. On things like content moderation, they don't. Right, so we have a very different view in the US about how to regulate speech than perhaps elsewhere in the world. How can these differences be reconciled by companies that operate globally?
Well, I wish we had an hour to talk about this, and but my short answer is we can't reconcile it. No one envisioned a speech marketplace with 3 billion people in it. Just the difficulty of somebody in Menlo Park, California, deciding what people should be saying in Myanmar is ridiculous. They're not aware of the fault lines. They're not aware of the political sensitivities, and they cannot apply a Western style set of speech standards to other places in the world that don't have them or have other competing cultural priorities. And, that's just the reality of the world we live in. So you either have to then localize all of these issues for speech, which is also difficult, or you live in the middle, which is where we are now, where everybody's unhappy. They're all saying, Facebook, Twitter, Reddit, you're just not doing enough. You're not controlling all the bad speech that's out there. And bad speech is anything I don't like, And otherwise, when they do step in and they ban people or they restrict people, then they are criticized for being censors and for being, who elected you to regulate my speech? I think that we're just in a really treacherous moment right now where everybody's going to be unhappy. And I don't think that the government is the answer, but I think that we have to have a greater awareness of the fact that these are private platforms that are trying to exert some sort of rules of the road. But whether 1,000 different communities are going to buy into those rules is a big question.
Okay, another question. How can regulators deal with the adversarial nature of the regulatory challenge? Insofar as companies may shift their operational structure to comply with the letter of the law while ignoring the spirit underlying it. And I think that was a question from the chat, and I think this comes back to some of what I was trying to ask about trying to enforce privacy by design, right? Like you can have a checklist, we did all these things, but it might be hollow.
Of course, it has to be real. And the checklist model, you start with that, but it has to be real. And by that, when I talk to companies, I say, look, what you want to convey to your customers is the lengths you go to protect their privacy, because you respect them, you respect their privacy, and you want to protect their data. It resonates, but it has to be real. So you have to walk the talk. And in walking the talk, it's not that hard. It has to do with stripping personal identifiers associated with the data that they collect in order to make use of the data for other, business related purposes. And there are, good ways of doing that and bad ways. So you can have very strong de-identification protocols combined with a risk of re-identification framework. There's a whole methodology on how to do that. And they're brilliant, Professor Khaled El-Imam, for example, is an expert at this. There's the creation of synthetic data, which is now growing enormously instead of the actual real data. So there's different ways of doing this. You have to walk the talk, and it has to be real.
Alex, any thoughts on adversarial nature?
I think Anne said what I would have said.
Great.
Better than me.
Oh, thank you. It's very kind.
So we have, related to your response then, and we have a question in the chat to expand a bit on the protocol to prevent re-identification of data.
Well, so a lot of that, and we're not going to have time to do it now, but go and look at the work by Professor Khaled El-Imam, 2 words, E-L, then E-M-A-M. He has amazing protocols on how you address the risk of re-identification. So it's not just simply, stripping the name or the social security number or things like that. There's much more involved. There is a methodology involved in doing this. And so you go to the experts, you apply that, and then you have solid de-identification data where the risk of re-identification is less than 0.05%. That's less than the odds of being hit by lightning if you go outside when it's raining out. Damn good odds. And that's what you can do. Companies have been doing this for a long time, using protocols like that. But you just have to be serious about it and take the time and look into it.
Another question in chat. Asking about the engagement, both from civil society and the public, that was sort of involved in creating the privacy by design framework, right? You got it out, proliferated it, all these different places. So how did that work?
I was really lucky. So I was appointed privacy commissioner for 3 terms, but when I first started, went to the office, and the office was full of lawyers, as you might expect. And I'm not a lawyer, I'm a psychologist. I bring a very different approach to it. I studied psychology and the law, but it's a very different approach. So I wanted a proactive means of protecting privacy, not just after the fact privacy laws, which is what was in play. So literally over 3 nights at my kitchen table at home, I created privacy by design, the 7 foundational principles, and I took it into the office and I sold it, if you will. It took a little selling because it's not a legal model, but I wanted it to work with the privacy laws in place. So it wasn't an attempt to replace the privacy laws. It was an effort to combine the two so that you have the strongest possible protection. And I was lucky because after 10 years in 2010, it was unanimously passed as an international standard by the International Assembly of Privacy Commissioners and Data Protection Authorities. And then it just took off. And as I said, it's been translated into 40 languages now. And honestly, not a week goes by when I don't hear from some jurisdiction telling me what they're doing and how they're doing it. And new privacy laws that are being introduced now, like Brazil just passed a privacy law. They've included privacy by design in it. So it's, if you look at the 7 foundational principles, it's, there's nothing magical about it. It's basic information in terms of being proactive, bake it into the code, into your operations, so that it has a constant presence.
Great. And Alex, I wonder if you have thoughts on public engagement in this space.
Yeah, I mean, like in any law, a privacy law, even if you think you have basic public support, I mean, privacy does poll really well. The California privacy law passed with 65, I think, % of the vote. But people have very different ideas of what privacy is and what aspects of privacy are important to them. And so, it is very critical to talk to stakeholders in the community. I think sometimes lawmakers tend to talk a little too much to law professors, and not enough to other groups in the society, and definitely groups in neighborhoods and groups of other minority groups in the community that might have a very different take on what you're trying to do in terms of instituting some privacy protocols. And it's a cliche, but you just have to be a good listener and understand what the community concerns are and try to craft some legislation that meets those concerns. Concerns about facial recognition are much deeper and widespread in some communities because of the potential for discrimination, whereas other communities look at it as a security issue. It's interesting that way when you're trying to craft a bill that deals with everything. And identifying the stakeholders is always going to be a secret to success.
And if I could add to Alex's comment, facial recognition is just appalling in terms of the lack of accuracy. False positives abound. In the UK, for example, in England, they have cameras everywhere. 81% false positive rate. I mean, it can ruin your life in terms of your identity, being identified as the bad guy and you're not. When I was privacy commissioner, a number of victims of identity theft came to me seeking my assistance and helping them restore their identity. And I always used to say, the first thing you should do, go to the police and file an occurrence report, something that verifies your claim that your identity has been stolen, and then we'll take it from there. But facial recognition in terms of one-to-many, very problematic.
Well, and just in the headlines, was it today or yesterday, Facebook announced that they are going to remove some of their facial recognition technologies.
Yes.
I don't know if that means I can keep my profile picture or not, or, I think people actually like to tag their friends, in posts. I mean, this is we're humans, right? We want to connect with people, we want to share with people, but I don't think we realize how that is being tagged and processed. So it's not just the use of the facial recognition technology. I'm sure Facebook took the step because it's not adding meaningfully to their advertising bottom line, which if you read about where they're going in terms of their overall advertising gains over the last few years is pretty amazing. I think they have 12% of digital advertising now goes through Facebook.
Wow.
Wow, that's a lot.
Yeah.
All right, well, thanks to both of you for a great conversation. I'm gonna send it back to Michael now to close us out, but I really appreciate it. This is great.
Thank you.
Yeah, thanks so much for that. As I struggle to make my video work, that was really interesting. I think that last point on facial recognition is a good place to end it, and a really interesting point to emphasize, especially because there are two problems there that kind of seem contradictory, insofar as there are concerns that these products are going to work too well and be too invasive and be too good at tracking us. And then there are also kind of efficacy challenges in terms of the product just being garbage and not working as advertised. And one would think that those complaints are contradictory, but they actually stack really well, because the only thing worse than sort of this panopticon that can track you everywhere you're going and knows too much about you is a panopticon that's riddled with errors and creating false positives all the time. Yeah, so that, I think that's a really key point to leave it on, especially as facial recognition is an area where our institute is looking at developing programming down the line. But for now, I will thank our two fantastic moderators, our two fantastic panelists and our fantastic moderator. I will do a quick plug for tomorrow, which is our big day, the culmination of this series, where we will have a series of conversations that's going to run all the way from 9 a.m. to 5 p.m. Pacific time, which will feature Kate Klonick and Nick Guggenberger and Margot Kaminsky and Jessica Deer and Nandini Jami and David Kay and Joran Marby and many, many, many more wonderful and distinguished speakers in order to elaborate more fully on a lot of the points and issues that were raised during this kind of introductory set of comments panels. So I'm really looking forward to that. It's at the same Zoom link. I hope that some of you will be able to join us for that. And in the meantime, have a great rest of your day. And thanks again to our guests for a fantastic conversation.
Thank you.
My pleasure. Thank you.